appeal for bail.
Retirement benefit, the order of challenging the order of tribunal.
Actually, item 14 here.
Yeah.
So they may be taken up for Monday because Mr. Mishra has a personal difficulty because of the
14,
death of Mr. Manoj Mishra.
Tushar Kumar Ranjan Bhari. You are for the petitioner.
I am for the petition.
So, any objection from the other
I
side?
have informed the Mr. Dilip Kumar Sahu, who is appearing for the opposite party. Union of Punjab.
Interim order is there.
Yes, interim order, there is no interim order.
So, dono batao.
Opposite party number 9 and 19 have not served.
No, they are
Services also.
Service
Which
on
That is-
postal tracking report item delivered.
that
That is to be lucky. Though the AD, though the office has reported, neither AD nor undelivered notice is back from opposite party number 9 and 19. But postal tracking report at flag X and flag Y indicate that items delivered in inverted comma therapy. Therefore, the notice on opposite party number 9 and 19 are held to be sufficient. Stop. Land counsel for the petitioner seeks for an adjournment till Monday. He further submits that he has obtained consent from the Land Council for the Union of India. Put up this matter on next week or then put up this matter on 13th August 2020. Yes.
Okay.
Yes. Mentioning.
Yes.
Item 13. I have instruction to appear on behalf of the registry, but file has not been handed over to me. There are other certain procedural formalities. So, in fact, I'll take consent from Mr. Pujari, and then I'll make a mention that he is not here.
You would be appearing for the High Court.
Yes, ma'am. Today morning they informed me, and they are going to engage a junior counsel also because he'll authorize me. So that procedural formality is there. It will take some time. So I'll inform Mr. Pujari, then I'll come back to Lordship.
Okay.
Item 34, my lord.
3-4.
Your lordship has called for a report. This is a case where the petition filed by the bank under section 14 has not been disposed of by the CJN. For that reason,
Earlier we withdrew and that's
earlier withdrew and thereafter filed.
you have filed it.
Yes, yes. No, this is not that matter. This is 7. This matter also we withdrew and thereafter filed.
Already filed.
Already filed since last 2 months. It has not been disposed of. Your lordship has called for a report.
The report has come.
Yes.
That is at flag 20.
I have seen the report.
Item number last item 30.
Last item.
Just a minute.
Yes.
Voluminous.
The case contains voluminous document for which hearing of the petitioner could not be concluded.
Order 7 Rule 11
Yes,
पक्के करते opposite party सब कर जो टाइम मेंटेन बोलते हैं सुनने की order कर लेगा.
So then we are granting some time and disposing of what is there.
I will Lord Senior SP Mishra is appearing in this case. I have to intimate about that. It can be disposed of by your lordship disorder.
Section 14 जो रहा pending ଅଛି.
The ଗୋଟେ general direction.
ଆଜ୍ଞା ଅଛି ମୋ ପାଖରେ order.
ସେଇ type ର କରିବ
ହଁ
କଣ?
ସେଇଟା
ଏଇଟା କୋଟ କରିଦେଇ ସେଟା କରିବ।
ଆଜ୍ଞା.
But the
opposite
delay is
party
caused because of the petitioner's applications after application, because the statute says that it has to be done in a particular time. And if you keep on moving application, it takes only obviously.
No, I am not moving.
No, I understand the other side.
They are moving only to delay because under section 14 there is no power for adjudication.
There is no requirement of even notice sometimes.
Notice is not required as per the.
We can't do it.
Expeditiously कर दे छाड़ दो बेटा। मुझे थोड़ा time की support करो। आज expeditiously as possible कर the Lieutenant CGM Cutter, CGM cum Assistant Second Judge Kapil, has submitted a report wherein in concluding paragraph, he has stated that since criminal miscase number 229 of 2024, whether it is 24 or 23,
24.
2024, it has been filed under section 14 of the Surface Eye Act on 21/11/2024, contains voluminous document, the hearing of the petitioner would not be concluded despite taking steps to have day-to-day hearing stopped.
ସେ ଆପଣ ଯୋଉ order ଟା pass କରିଛନ୍ତି common order
1063.
ଆଜ୍ଞା ଆଜ୍ଞା
The Lieutenant Counsel for the petitioner, bank produces orders dated 21/7/2025, passed in WPC number 10628 of 2025, along with connected matters, where taking into consideration the proviso to subsection 9, Roman 9, to section 14 of the Surface Eye Act, and the decisions of the Honorable Supreme Court in the case of R.D. Jain and Company versus Capital Fast Limited, reported in 2023 1 SCC 679. We have passed order directing the executive magistrate or the district magistrate to adopt a procedure to scrutinize to dispose of within stipulated time frame provided and mandated under law. So, since it appears that the period stipulated under section 14 of the Surface Eye Act in this case is already over. After considering the report submitted by the Lieutenant CGM, we expect him to dispose of the criminal miscase as expeditiously as possible.
I will intimate Lieutenant Senior Adjutant. Their presence may be noted on the
Minor stand permission out of this nothing. That admission.
Yes.
That was dismissed by the Learned Tribunal on the ground of limitation, which is the regulation out of list. And on the ground of limitation, the regulation matter and the Learned Tribunal dismiss on the ground
You are
of
filing memo to list the matter of give. Yeah.
on 13th, Lord, I am praying.
Uh,
On 13th, I am praying.
okay. Yes.
Supplemental list, item number 1.
This case, I have filed a memo. Prior to this matter can refer to mediation center.
The appointment letter, regular bench again.
You are appearing for?
I am for the petition.
I am for the union of.
Union of-
What is the prayer in?
I have challenged the order on tribunal matter.
What was the order? Like, what is the
Matter
direct?
relating to engagement or substitute. My candidate rejected only on the ground that I have a law graduate. for first time. This tribunal remitted matter back to tribunal. Again rejected in the same term. Relying upon a document, my lord. In this case, in one part, tribunal have upheld that this document I am relying upon. On the second matter, no, this document is against him. That's why I am making a prayer that this case can be referred to mediation. So that is remitted back in tribunal for hearing application.
Substitute in Group D category.
Group D.
Group D category.
2012 OML.
So what do you say, Mr.? Whether we'll send it or if you give some positive indication, then otherwise it will be decided on merit. What is your
Let's say-
instruction?
I have no instructions, my lord.
अरे सही में पूरा लिस्ट ही मैटर था.
The mediation जाओ.
I am making prayer.
हाँ, पटेगा mediation. The formatter पटेगा. Yes.
The second item, my lord, there is a noting that reason or not filed. Yesterday I have filed. After serving a copy on my.
Yes. No, it's
My
one
lord,
thing, but about the
Also, I am prayed for this
Mediation.
matter may be referred to mediation.
It can be.
My lord, it is a matter related to seniority of the petitioners. And it may be heard on merits, man. We'll file a report. We'll take instruction on.
My lord, this case is covered by my order of this court dated 5/5/2022, pass in double fish number 1665920.
No, it's all right, but if it is a
Seniority matters.
seniority matter, it cannot be as well. Let's do the
Private respondents.
AD has returned from opposite party number 5 to 10 after valid service. Hence, the notices on OP number 5 to 10 are held sufficient. None appears for the opposite party number 5 to 10. Stop. So, in the cause list, it is mentioned that rejoinder affidavit has not been received, but the Land and Council for the petitioner submits that yesterday he has filed the rejoinder affidavit to the counter affidavit filed by opposite parties number 1 to 4. Stop. Copy you have also sought.
Okay, I will.
My lord, we will see.
He further submits that copy of the rejoinder affidavit has been served on the Land Council for the Union of India, which is not disputed by the Land Council for the opposite parties number 1 to 4. The rejoinder affidavit be placed on record. Stop. Both the Land and Council for the Union of India submits that since the petitioner is challenging the seniority aspect, this matter cannot be settled in the mediation. Stop. In view of such submission, place this matter before regular bench for final disposal. Since pleadings are complete. Yes, date is over.
Item 2,
Google Opera.
item 3,
Minutes. In this case, next specific prayer with my lord to direct the district master Jagasambur to dispose of my section 14 with respect to
The same story.
minutes, yeah.
No, it's not numbered.
Number ହେଇଯାଇଛି.
It has been
Page of 23. So I prayed only to Monday. It got developed.
When this, we will dispose it of within the.
Why do I have intimate?
2023 of.
Mentioned about an incident which can also putting in notice already been issued with the ଏଟା ପୁରା ନମ୍ବର ହେଇଯାଇଛି 50
ଖାଲି twice it was communicated. I pray for Monday in development.
Notice was published also in Odia newspapers ଦେଇଛନ୍ତି ସବୁ petitioner bank absent ଥିଲେ 20/6/2024 ରେ next date was fixed to 10/7/25. Why you are remaining absent?
Because no date was communicated to us here. So
No, you should take the date. Lekha is petitioner bank was absent on the date fixed. That is on 24/6/2024. And accordingly, the case was adjourned to 10/7/25. We do not know whether on that day you appeared or not. because
note is not-
it is a letter dated 36/25.
But it is pending since 4th October 20.
Already to see we are passing the similar direction.
Yes.
जो अच्छी तरह
अभी जो ग्रुप
अभी का जो होगा ना सही टाइप का डिस्पोज ऑफ कर
Okay.
खाली
If
लेटर
not disposal.
हाँ
If not disposal.
हाँ नहीं डिस्पोज ऑफ केमती हो ये पांच एटा नोटिस ही जाए लिखी जाती खाली दी peruse the letter dated it लिखी देवे ना 36/2025 of the deputy collector judicial collectorate Jagatsinghpur, wherein it is stated that the case number 50 of 2023 under section 14 of the Surface Area Act, after the initiation of the case one, so under section notices issued to the opposite party, and then notice was also published in the Odia daily newspaper, the Samaj, on 1/3/2024, and the petitioner bank was not present on 26/2024, and accordingly the case was adjourned to 10/7/2024. Stop. It is further mentioned, requested to grant few weeks time to adjudicate the case. Stop. Since this letter is dated 36/2025 and 3 weeks have already been is already over, if the case has not been disposed properly.
In my lord's judgment.
সেটা আমি পড়ব।
Okay.
Item 4.
It is like a rice mill again. With the procure ready man, you have to call this bank guarantee man. And since 2020, man, he is furnishing bank guarantee from the bank of
You are challenging a letter.
letter by the ombudsman. Man.
What is there in that letter?
My lord, they have only, well, I have challenged the excess amount charged by the bank over my bank guarantee.
Come to that letter.
My lord, your lordship, I can have a glass too.
Annexure 7.
Annexure 7, page 27. Here. Paragraph 2.
Paragraph 2. You have raised complaint related to delay in issuance of bank guarantee charges, bank guarantee and credit interest fee bank guarantee. In this regard, the comments were sought from the regulatory entity, Bank of India, and examiner. It is observed that the bank has refunded the excess limited charge of rupees 88,500 to her account in February 17, 2025 for bank guarantee issue on 3/8/2020 and refunded the excess debited charge of another 88,500 to her account on March 25, 2025. Rs 2,95,000 for bank guarantee issue on 14/12/2021 and 59,000 for bank guarantee issue on 28/11/2000. Hence, your complaint is treated as resolved and close with us. And my humble submission, my lord, your lordship can have a glance to page 25 and extra 5 now. The last paragraph, my lord. They have not refunded the 20 and 21, my lord. I have only received the last. They have only
2021 মানে কোন
2021 my lord. They have charged the excess of 71,000. They have not refunded.
Acha, 21/12/2020.
My lord.
And they are only talking about the last one.
Last two, not close.
3/1/2025. That they have refunded. 88,500.
500.
But the rest of the thing not.
Not taken into consideration, and I have raised objection before the ombudsman.
Have you grievance only against this item number 1 or 1, 2, 3, 4?
1 to 5 men.
आइटा पूरा कहो
आगे 1 2
5टा तो मिल गया आपको
आगे
एक रु 4 मिलनी
आगे
the bank manager has credited एडी भी आपण लिखी जंदी चिट्ठीटा रे जो annexure 3 रे last paragraph रे आपण लिखी जंदी in this connection I am to say that the branch manager credited 2.58
आगे
329 towards
Interest of
interest and 88 were transfer instead of the two EFI.
total 4 lakhs.
Total
Total 4 lakh 31 ru 88 दी. Kindly करें.
क्रेडिटेड आपण कर देछंदी एटा
4,31,000 टका पाया କଥା
पाया था अब
2 ଲକ୍ଷ ଦେଇଛୁ
88
ବେଷ୍ଟ ଆମାଉଣ୍ଟ ଟା
ଦୁଇ
ଦେଇଛୁ।
ଅଠାବନ 258 329 ଆପଣ ଇଣ୍ଟରେଷ୍ଟ ବାବଦ ପାଇଛନ୍ତି ନିଜେ ଲେଖିଛନ୍ତି
ଆଜ୍ଞା
ଆଉ 88 5000 ରିଫଣ୍ଡ ପାଇଛନ୍ତି
258
ଆଉ କେତେ ରହିଲା ଆପଣଙ୍କୁ
1 lakh something 2 lakhs ତାର
4 ଲକ୍ଷ ରୁ
କିଏ appeal କରିଲା
notice
My lord, I'm appearing for copy number 1 only.
bank.
No, your lordship, Union of India.
then
We do not
Yeah,
have
you
it.
don't have it.
only by
Bank.
notice to bank authority matter 3 and 4
Yes, sir.
The writ petition has been filed by Mrs. Ma Samalai Rice Mill with a prayer for passing the letter dated 27/3/2025 issued by the Ombudsman, RBI Ombudsman, Reserve Bank of India, Ombudsman. That is opposite party number 2. With a further direction to the opposite party number 3 and 4 to refund a sum of rupees 2,56,772 at a war civil exam to the petitioner, which was the excess amount charged by them for furnishing bank guarantee. Land counsel for the petitioner referred to the letters issued by the petitioner to the Reserve Bank of India dated 10/3/2025, wherein it has been stated that the refund amount, the total refund amount is 4,31,272. Under 5 different headings, then the Land Council for the petitioner has referred to the informed letter wherein it is stated by the RBI Ombudsman that the bank has refunded the excess debited charge of 88,500 to the account of the petitioner on 17/2/2025 for bank guarantee issued on 3/1/2025, and I would have refunded the excess debited charges of another 88,500 to the account of the petitioner on 25/3/2025. Bracket rate and therefore the complaint which was filed by the petitioner by the annexure 3 was closed. The Land Council for the petitioner submits that in view of the amount received by the petitioner in his account, in view of the credit of the amount in his account, in the account of the petitioner is still entitled to get a refund of rupees 2,56,772. But nothing, no order to that effect has been passed under Annexure 7. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. No notice be issued to the opposite party number 2. Opposite party number 2 को तो तांगर अच्छी ना पैनल काउंसिल ना कौन है?
2, 3, 4 को notice नहीं
अच्छा 2, 3, 4 को notice पटे जाएंगे. So far Union of India is concerned, you have to file your appearance memo.
Yes, your lordship, I'll file it.
Give the name, file the appearance memo. You have received the copy of that?
Yes, your lordship.
Yes, submit that he has received the copy, and so far as 2, 3, 4 are concerned, the it is to be requisites for issuance of notice to file within a week. Matter be listed after 4 weeks and counter affidavit if any filed in the meantime. Yes. Okay, great.
Item 5.
May I please your lordship? So this is a matter there for regulation. Before this regular hard litigation, my lord. And my lord, I am telling the annexed one, the judgment in the third occasion, my lord. And wherein honorable court has issued direction, my lord, page 32.
Come to paragraph number 8, page 31.
Page 31, my lord.
Paragraph 8.
That only ground raised by the respondent for rejection of the claim applicant is not having been upgraded the minimum educational qualification of matriculation or ITI pass came to effect from 1/1/2006, much before the initial engagement of the applicant in 1984 and confirmed this temporal status in the year 2004, which held not to be not in accordance with the law. In the particular facts and circumstances, the matter is also law laid down by the Honorable Appeals Court in a case of Jago Supra in bracket impugned order dated 15/2/2017 and 12/7/2019 reserves to be quashed, and the same are hereby quashed. The respondent are directed to issue consequential order of regulation with effect from date of when the applicant's counterpart employee was regularized within a period of 60 days from date of receipt of the copy order. In the event, he shall be entitled all the consequential service benefits so far as the financial benefit are concerned. Them shall be
So your original application is allowed.
My lord,
Why have you come?
not allowed, my lord. In my sense, my lord, I was joined.
Why stands allowed?
My lord, this is my counterpart junior to me were regular on date of when my junior were regularized. That I'm challenging. Not a single junior was regularized. For that reason, they cannot consider my case because of no junior is regular.
Where is your original application?
Now I'm giving my Annexure 10, man.
Where is your original application?
Original application I have not filed, but the order I have filed, my lord. The first way, my lord, Annexure 10. Annexure 10 kind of first way or
the persons who, according to you, your juniors, but they have been promoted.
They're not
No,
regular.
none of them are promoted.
None of them have been promoted.
Regularized. None of them are regularized.
No, none of them.
None of the junior is regularized. So therefore, the direction is direction is to regularize you from the date when the juniors are regularized. Your grievances, juniors are not regularized. How will I be regularized?
But I am coming under the provision 53 of the Umadim case. Why I am my
That
junior
is a
regularized?
different.
I am saying regularized.
You move now.
That order is contradicting first order and second order of the way. For that reason, I am saying. My lord, kindly
But you file a review. This is a wrong direction. Having allowed your OA, the direction is not executable. That's your case.
My lord, my responsibility only. I am also challenging because even if they regularize, that is also wrong.
That has to be adjudicated by the OA. We will not adjudicate.
My predicament before that itself not also wrong in my case because I am eligible to regularize in view of the paragraph 53 of the case 2006. Even if a junior regularized today, then tomorrow I will be regularized. That's also I am challenging. Annexure 10 and 11 kind of thing.
Where have you stated that none of the juniors have yet been regularized?
No, I am giving my list in Annexure 5.
No, and the writ petition where
the aberment to that.
Aberment Annexure 5 can you see? My lord,
After the aberment, we are not going to answer. Because those persons are neither parties in that way nor parties here. So anything adverse passed against them will be not proper because they are to be heard in their case. If you are claiming that
I placed in paragraph 53 of the judgment of the Umadevi.
No, we know that. Come here, where is your aberment? That none of the order is not executable because of this, the last line which has been stated that the respondent has directed to issue consequential order of his regularization with effect from the date when applicant's counterpart employees were regularized. You mean to say what the submission of yours that none of your counterpart employees have been regularized. Is it your contention?
Not regularizing submission.
Come to para 18 of your writ petition.
Tribunal has not properly applied his judicial mind taken to direction of this Honorable Appeals Court Umadevi para 53, wherein Honorable Appeals Court categorically stated the process must be set motion within a period of 6 months from the date. The judgment of the Umadevi pronounced in court 2006 within 6 months with date of judgment as 10/10/2006. Union of India must be carried out said order by regularizing the service of the petition on the said date, that is 10/10/2006. So the direction of the tribunal directly the opposite party regularize the petitioner when the counterparty employees were regularized. Hence, the category pointed out that the petitioner never stated anywhere that his demeanor was regularized. In the absence of such finding, the Honorable Tribunal here is
125.
but the direction giving the counterpart.
You are saying, let us be clear about it. You are saying you obtained your improvised qualification of matriculation ITI in 2006. Isn't it?
No, that's it.
That is what you are saying. From 2006 you are entitled.
For that reason, Para Annex 10 and 11 very much clear. Para 10 and 11 is very much clear. Para 10 Annex 10 it is a first tribunal order where is direction is giving to representation my representation is a region order. And they have region by my kind of just para Annex 10.
They have approved the Supreme Court.
These order my lord will satisfy. Annex 10 page 51.
File a detailed affidavit.
51 next page 52. First para they have stated the tribunal order. Second para 2. When a person entry to the temporary employment to get engagement on contractual or casual worker, the engagement is based on proper selection as recognized the relevant rules and procedures. It is aware of the consequence the appointment as being a temporary, casual and contractual nature. Such a person cannot invoke the theory of legitimation being conformed to the post when the appointment to the post would be made only by a following proper procedure selection and control case. In consultation of the Public Service Commission, therefore the theory of a legitimate expectation cannot be successfully advanced by temporary or contractual or casual employee. It cannot be also be held that the state has held to put out the promise while engaging these persons either continue where they were make them permanent. The state cannot constitutionally make such promise. It is also obvious that it cannot be invoked to this.
Come to para 7.
Second.
No, come to para 7 of the tribunal's order. Come to para 7.
Para 7.
Tribunal's order, page 30. 30. Para 7 of the tribunal's order, which you challenged. Now read it.
Para 7, it is notable that the engagement of the applicant was against the Group D MTS builder. All the Group Ds were upgraded to Group C post PBI on 1800 on the recommendation of 6 TPC, which came into effect on 1/1/2006. And the educational qualification of the appointment of the MTS was made matriculate and ITI pass. The applicant was engaged as a casual basis and discharged the duty of builder in 1984 and confirmed the temporary status 2004. Which is obvious and much before the upgradation of the qualification of the application or ITI. As per the temporary status scheme, the holder of the temporary status are eligible to be regularized and thus applying the upgraded qualification which came into effect from 1/1/2006 and the rejection of the case of the applicant is certainly not acceptable in the eyes of law. The case of the applicant ought to have been considered by qualification in 2004. It is not a case that the respondent that work of the applicant was not found satisfactory during the 2 decades, but be as it may be, we also find that the claim of regulation is the process of the engagement in different modes other than the regular process. Even person engaged for a considerable long time without having essential qualification came up the consideration before the Honorable Appeals Court in a case of Jogo and the Union of India and so and so. The Lordship of the Honorable Appeals Court taking the note of the various decisions, including the case of Umadevi, was the order of termination of the employee and concern and direction to the reinstated regularization. In the said case, it is also observed that para 17.
This finding is in your favor?
No termination. My lord, my anxiety, my lord, what happens now? Kindly allow me 2 minutes. First of all, I came approached the Honorable 2014. Tribunal said that representation be considered. Representation they were taken a ground para 44 of the Umadi. Only para 44 that he has not regular selected, for that is regulation convert. And that was in quashed in annexed by the tribunal. That order is not sustainable, that he has not pleaded anything. So only para 53 is improved and directed in 2016 that his service may be regularized by quashing annexed first order, that is 2014 order. Quashing and direction. That order was not executable by, and his another plea has taken when para 44 was taken Umadevi, and next another ground taken, he is not immaculate, he has not passed ITI, nothing else. Now the corrigendum passed by the Union of India, I have filed, ITI or maculation is not necessary because of the pay band which has crossed to 1800, that is eligible for regularization. That corrigendum I have annexed. In view of that, Honorable Tribunal directed me to regularize. Still then they are regularizing on the new plea that I have not passed maculation. That is not sustainable, that is first, and that order has been passed in the third way. That I am challenging. Why I am on the date of my junior, I am eligible as per the Umadevi case, para 53. 6 months ଭିତରେ ମୋତେ ରେଗୁଲାର କରିବା ପାଇଁ ଡାଇରେକ୍ସନ ଟୁ ଦି ଅଲ୍ ଦି ୟୁନିୟନ ଟେରିଟୋରି ରେଗୁଲାର କରିବା ପାଇଁ ଆଇ ଏମ୍ ସାଂସନିଂ ସେମାନେ ଆମେ କଣ୍ଟିନ୍ୟୁ ସାଂସନ ପୋଷ୍ଟ.
Permission to file the review petition because of the limited time.
I pray one thing,
The repetition
because my anxieties. 2006 Umadevi para 54.
Try to appreciate one thing. We have to see the perversity. It is allowed in your favor. It needs to be adjudicated. The tribunal in the para 7 has given a finding in your favor, and para 8 passes some order.
I pray before you.
Do you go there?
My lord, I pray before you. That candidate, that petitioner, the Bredidin, retired service since January 2025, and the Bredidin, my lord, only appropriate order may pass to the minister, and he will get some. And he is coming to this court, my lord. This is because, my lord, one line. In 2092, he is continuous.
You will observe that your review petition should be expeditiously.
Must file the writ petition challenging the order dated 17/1/2025, passed in OA number 260/00331 of 2022, passed by the Learning Central Administrative Tribunal, Cuttack Bench, Cuttack. The original application was filed by the petitioner with a prayer for his regularization, taking into consideration his engagement as casual labor, bracket repair, bracket ends from 10 to 1984, and and grant of temporary status. What is your prayer in that?
My prayer was immediate regularization.
No, what is your prayer?
Taking into Umadevi case.
Where has been quoted here? In the, that is why we are asking you to file that original application copy. Have you got the original application copy? Give it. We are repeatedly asking you that give the original application copy. And also the pleadings, entire pleading. As a call is a prayer to quash the order dated 15 to 2017 and 12/7/2019. And to direct the opposite parties to regularize the service with effect from the date of purchasing vacant sanction post, that is 1/2/1992 as per the official letter number 937 dated 3/6/2023 with all financial benefits within a stipulated period. 15/2/2017 টা কোন?
সেকেন্ড হইব সেটা আনেক্সার 11 সে ফার্স্ট রে মতে পারা 44 এর
15/2/2017 অর্ডার কাই
অর্ডারটা আনেক্সার 11 সেটার মানে ডাইরেক্ট করলা রেগুলার
আনেক্সার 11 মানে কোটা এই রিট
এই ওইর রিট আনেক্সার 11 টা
আনেক্সার 11 is not 15
মানে আনেক্সার 11 Annexation page 54 to 69. This is the cross of the case, man. Page 69 can
ପଚରାଉଛି ସେତିକି କୁହନ୍ତୁ ଆପଣଙ୍କୁ ପଚରାଉଛି ଯେ the prayer is to quash the order dated 15/2/2017. Query that order 15/2/2017.
that is page 64. 64 the direction of the
ଯୋଉ ଅର୍ଡର ଗୁଡାକ ଏଠି ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ସେ ଅର୍ଡର କପି କାହିଁ 15/2/2017 and 12/7/2019 କିଛି ଫାଇଲ କଲା neither the original application nor the entire pleadings have been filed by the petitioner in this writ petition. Let the land council for the petitioner file the entire pleadings in OA number 331 of 2022. Yes, next. Put up this matter after the entire pleadings are filed. Yes.
Item 6.
I may be perimeter, your lordship, I am in virtual mode. The matter may be taken over after lunch, sir.
After lunch, there is a different bench total. The land council for the petition of 6 for an adjournment. Next.
Item 7.
I'm filing a memo giving the number of the criminal miscase filed for
This is the one which you have withdrawn and filed it.
Yes. And I have filed my power in the registry also. Criminal miscase number 325 of the
Then that would be disposed of
As per your
in view of the
1068.
The memo has been filed by the land council for the opposite party number 1 that the petition under section 14 of the SAR which has been filed before the land CGM cutter on 6/8/2025 has been numbered as criminal miscase number 125 of 2025. The memo is taken on record. Who is for the petitioner?
I am for the petitioner.
So what is your prayer?
I am basically challenging the inaction on the part of the OP number 1 for providing me the vacant position of the land.
The writ petition has been filed by petitioner Messrs. Orissa Poultry Private Limited, who is the auction purchaser, for directing the opposite party number 1 take immediate steps to deliver vacant possession of the purchased property to the petitioner in pursuance to the sale certificate issued within stipulated period. Since section 14 petition has been filed as stated by the land council for the opposite party number 1 on 6/8/2025. After a decision term of the
25/7. 25/7. First second part. Everything you will take.
It's a better application file.
Better application
Better application
file.
file, which is numbered, and it has to be disposed.
It is to be disposed of in terms of the order. What say you? The copy टा अच्छी है अपन पर. हमें जो order का pass कर.
ଆଜ୍ଞା
ଏବେ ଯୋଉ ଦିଆହେଇଥିଲା
ଦେଇଥିଲି ଆଉ ଗୋଟେ ଦେବି
batch matter.
Batch.
ଅଛି ମୋ ପାଖରେ ଅଛି ମୋ
That has been mentioned in the That should be yes. Disposal. So some of the thing is very for this.
Item 8.
Item number 8, as per the last order, and as per the submission, I had deposited rupees 5 lakhs before the bank and filed the affidavit before the honorable court. Fact B is my affidavit, my lord.
Now we can send it to mediation.
Yes, my lord.
Last time he said that ready is willing to deposit 5 lakhs. He deposited last for affidavit file for. Once you can jama karti, we can send it now.
The
Upfront funds.
Land counsel for the petitioner has filed an affidavit of the petitioner in compliance of the order dated 6/8/2025, wherein it is mentioned that the petitioner has deposited an amount of rupees 5 lakhs in his loan account
As against demand of 15 lakhs 80.
Before the SBI Yoda branch against the demand amount, outstanding of the demand amount of rupees 15 lakh 88,254, and thus the outstanding rest, thus the balance amount remains is rupees 10,88,254. It is further stated in the affidavit that the petitioner is ready and willing to deposit the rest of the outstanding amount if it is considered by the bank for one-time settlement.
Yes, my lord.
Stop. And further, it is stated that the OTS application dated 5/6/2025 is pending before the bank. Proper mediation curriculum portfolio. Yeah.
May I permit during that period the bank may not take any post-grad.
See, upon bank में तो
हमने उसे गुरुदत्त करो नो इंटरेस्ट ऑन कॉम
हाँ
नो इंटरेस्ट ऑन
Yes,
No
file
issue.
affidavit. Yes,
copy
file.
representation copy and affidavit already sent to the bank but no instruction.
अच्छा हो अश्व इंस्ट्रक्शन हम mediation तो करती है
You won't participate in the mediation.
mediation yes.
My only prayer is during that no coercive action against taken me, my lord, against me. I have deposited and I am willing to deposit whatever the amount will be settled before the mediation, my lord. So during that period, no coercive action only.
We are sending it to mediation. We will not pass any order. Otherwise, we
Won't be
will
there.
flouting the order.
Once we send to mediation, nothing will happen.
Tell before the produce this order before the bank. The since no one is appearing for the bank, let a copy of the order be produced by the London Council for the petitioner before the bank authorities. Yeah.
Item 9.
Date of the instruction received.
कौन है?
Elder father, my lord, death. Due to the death of my elder father, I filed an interval for
elder father petitioner is the big son of the parents.
But they say that it's not required to.
There are the chari bhai achanti.
obsequious ceremony. So
There is the last part election.
Is not required to attend the few ceremony.
The petitioner was arrested and forwarded to so and so. Who did he put on the? Who are
The petitioner, next part, the petitioner, Ullah alleged Kamal Lochan Mahant was arrested and forwarded to the 10/6/21. Petitioner Ullah is the principal accused in this case, who was hewed the neck of the Hare Krishna Mahant of 15 years.
And
risk of the life of the
তার বড় বাপা মরছেন।
There is no financial problem for the arrangement that is mentioned in last part 4 lines. Obscure ceremony of other death.
Your elder father has died. The elder father has son, four sons.
4 sons, 2 daughters,
You go and
grandsons, one so, and no financial problem. So, but they have also stated in instruction that there is no need for you to attend it, and other safe is and there is also law and order situation.
ନିଜ ବାପା ବି was out of station ରହୁଛି ସିଏ ଏବେ ଆସୁଛି ଆସିନି because of that tense situation. 15 ବର୍ଷ ପିଲାକୁ
IN number, you move this matter on merit to receive that. Like IN number 2186 of 2025, there is an application for interim bail. Though the interim bail has been sought for on the ground of death of the elder father of the petitioner, but the Learning Council for the state has obtained written instruction dated 8/8/2025 from IAC Morada Police Station, Moyurganj, to the effect that the elder father of the petitioner has got 4 sons, 2 daughters, and also grandsons, and there is no financial problem for arrangement of the obsequious ceremony. It is further stated that there is likelihood of law and order situation and also the risk of life to the petitioner. In view of the written instruction produced by the Land Council for the state, we are not inclined to grant interim bail to the petition. It is accordingly rejected. Yes.
Item 10.
May I please your lordship in the matter? I'll oblige your lordship by applying the documents by the registrar. This is a very sorrowful matter.
Who is appearing for the Union of India?
Rest for two time, lordship, for some instruction required for the department, your lordship.
What you have handed over now?
Read petition and document annexure.
Aji dele?
Yes, the Kali Detili. Kitch nahi lordship, I will glance now. The latest judgment of Supreme Court.
She wants adjournment.
All right.
Let examine then.
Oh, sorry. Oh.
So once you handed over the writ petition to her just now, yes.
Direction nahi thala samajh lova kisi bhi nahi chandi movie nahi.
ठीक है.
Pen drive nahi.
Hela to.
All right.
From the Learning Council appearing for the Union of India submits that he has received the entire pleadings of the writ petition, and she seeks some time to obtain instruction. And counsel for the petitioner is present, put up this matter. Put a saptah around this matter in the commencing from 18th of August 2025. Yes.
Item 11.
Mr. Puntia.
May I please, your lordship? In this case, I have prepared a date chart, my lord. Written note of submission and
Who is appearing?
My lord, I am from Union of India. I tried my level best to obtain this file, my lord. Since this file has not been returned by the previous council, this is not available to me right now. I am feeling very embarrassing, my lord. I should not say that.
every time you have taken time, my lord.
Well, first time,
Previous council,
I will be allowed to take it through pen drive, so that on next date, my lord, I will get ready. First time this has been allotted to me.
Last occasion they have stated. Mr. Samatra is appearing. On last occasion they have taken time, my lord, on this ground.
ଆମେ ତ ମନା କରୁନଥିଲୁ ନା ପେନ୍ ଡ୍ରାଇଭରେ ନବାକୁ ବୋଧେ ପରମିଶନ ଦେଇନୁ କଣ?
The writ petitions are
Our mistake. He is allowed to do it. You cannot do.
Sometime you have to argue.
Last chance may be given, I will get ready.
But take the pen, collect the document today.
Today.
Otherwise,
Yes, we will collect today the pen drive. Yes.
Date chart also sought, my lord. Written
Date
note
chart
and date
also.
chart.
The Land Council for the petitioner sought the written note of argument on the Land Council for the Union of India. Stop. You have also filed for the court.
My lord, I appeal.
And also filed for the court, same is taken on record. The Land Council appearing for the Union of India submits that the brief is not traceable and he may be permitted to take the entire brief in his pen drive. Permission is granted. Put up this matter on consensus of both the parties. Let this matter.
Next week, maybe.
Next week, I want to. 18 से 18/8/2025. Yes.
Item 12.
It may be excused, my lord. Item 3 was lordship director that has disposed of. That copy I have there, sir. Item 3, जो जगह से that has disposed of. That copy
Section 14.
Section 14.
Which was fixed after.
Just now we
We are
received.
seeking 3.
They do not.
दे दीजिए उसे copy print.
এটা কি ডিকটেশন লিখলে শিখুন বোধ লিখলাম তা কই দেব আমি তাকে ଗୋଟେ ডাইরেকশন ଦେଇଥିଲୁ যে dispose of expeditiously ବୋଲି ସେ portionটা କାଟି ଦବ ଲେଖିଦେବେ land council for the state has produced the report wherein it is indicated that the said case has already been disposed.
10/7 সেই দিনে করো
10/7.
Accordingly,
Copy
the
of the order.
petition is also disposed of. Yes. Next.
Become infractions on this.
You have to add to that.
Kindness to the order dated 18/7/24.
Item 12.
No.
What's happening?
Your Lordship, kindness to the order dated 18/7/2024. Your Lordship already carved out the issue which is to be adjudicated by the Honorable Court. Mr. Ojhal, an advocate, appears on behalf of the petitioner and submits two reliefs were sought by his client.
Who order?
18/7/24.
Mr. Ojhal, an advocate, appears on behalf of the petitioner and submits two reliefs were sought by his client in the Central Administrative Tribunal. Second relief was regarding seniority denied. He submits the matter of seniority is to be guided by office memorandum dated 10th September 1985 and 12th September 1988 issued by the Department of Personnel and Training DOPT. He relies upon para 2 of the second memorandum reproduced below. The matter has been re-examined in the light of a recent judicial pronouncement and it has been decided that the instructions quoted above may continue to be followed subject to the modification that among the person in the figure grades given in same grading, those in higher scale of pay will rank senior to those in the lower scale of pay. The Central Board of Direct Taxes CBDT issued instruction dated 6th April 2009 in the matter. His client's claim to relief regarding seniority was denied upon the reliance upon instruction. Paragraph 2 in the instruction is reproduced below. The clarification relating to qualifying service of the 3 years and inter-se seniority with respect to the ministerial and stenographer's grade as arrived at the meeting has since been approved by the chairman CBDT. A copy of the note containing the approval such and such is enclosed. He draws attention to paragraph 11 in impugned order dated 9th April 2019 made by the CAT to demonstrate there was noting of no conflict between DOPT guidelines and said instruction interpreted as guidelines issued by CBDT. The order therefore is not based on the material available.
I am sorry to interrupt, my lord. My lord, I am sorry to interrupt, my lord. This concerned council's relation is died. That's why he informed me that it may be taken some other place. Just is gone to this village. Mr.
Raiguru's relation. So we'll take up this matter next week or a week after?
Next week. Next week.
Okay.
You will appear in the.
Mr. S.K. Ojhal and counsel speaking for the petitioner is present. Deputy Solicitor General Mr. Parhi submits that Mr. B.S. Raiguru and Central Government Counsel, who is supposed to argue the matter on behalf of Union of India, is unable to attend the court today as there is bereavement in the family and seeks for an adjournment till next week. Put up this matter on 13th of August 2025.
Item 13.
Yes, Mr. Pujari.
that in that matter, they have filed one affidavit pursuant to my lord's direction. The copy টা মতে দেই না।
Mr. Pari, some one additional affidavit, court account of
সেইଥିରେ last କୁ ଲେଖା ହେଇଛି copy not served. They have filed the affidavit.
rejoinder affidavit by opposite party.
I'll instruct Mr. Saraigur to serve the
Reply affidavit. Learned and counsel for the petitioner, Pratham Ritalagun, submits that though a reply affidavit has been filed by opposite party number 1 to 3 to the rejoinder filed by the petitioner, but the copy of the reply affidavit has not been served on him. Stop. Mr. Deputy Solicitor General submits that he will instruct Mr. Raiguru to Land Central Government and Council to serve the copy to the Land Council for the petitioner. And last 2 years, put up this matter on such and such. Yes. Yes, he was making a mention that he has been interested to argue this matter and one counsel is to assist him. So that instruction, so we are to adjourn it to some other day. Now, both of you are to tell the date.
I pray first week of September, my lord. I pray subject to my lord senior consent. Then it's first week of September, my lord.
25th of August.
बहुत छुट्टी होती सर 3 दिन छुट्टी होती बहुत दिन ये होती सर आओ प्रेस होता है बहुत दिन ये
इतना कौन प्रोग्राम और वर्तमान अच्छी
To system analysis. Upgradation of post of programmer to system analyst, that is the pair.
Right. So then we are keeping it to September 8th. Mr. Sarmal and senior advocate submits that he has been instructed by the Registrar Judicial Orissa High Court to appear for the High Court in this matter, and he requires some time to prepare the case. Stop. On consensus of both the parties, the matter will state we commences from 1st September 2025. You are filed the appearance.
I filed the appearance memo.
Appearance memo you filed in the meantime. Yes.
Item 15.
Mr. Kanungo.
That's item 15, my lords. In this case, today morning, my lords, Mr. Pratik Das requested me that because of sad demise in his house, my lords, it may be adjourned.
Okay. So, Mr. Niyamati Land Council appearing for the which number opposite party?
I am for my lords, Bank of Baroda.
Opposite party number 1, 2, 2, 3, and 4.
My lords, 2, 3, and 4.
2, 3, and 4 submits that he has been requested by Mr. Pratik Das, Land Council, for the petitioner that there is a bereavement in his family, therefore he will not be available. Stop. In view of the submission made by the Land Council for the opposite parties number 2 to 4. Mr. Kanungo.
My lord, actually, counsel assisting me, his uncle has died. So
we have noted down that it is to be adjourned to next week or
Next
week after. All right.
Week after next moon, 9.
Then 18th.
18.
This matter on 18th, 8/2025. Okay.
I appear for OP 5 lords.
Mr. Sarangi Land Senior Advocate, opposite party number 5 is present. Yes.
If there is any entry, I don't even have the file.
Just a minute. Any interim order passed, Mr.
No,
Niyam?
no interim is there.
No interim order there.
No, nothing is there.
Then
No interim order.
obliged.
Item 16.
So with due consideration, my lordship, ଏଇଟା ମୁଁ ଆଉଟ୍ ଅଫ୍ ଦେଖି ମୁଁ ବି ଦିଟା ରିଡ୍ କରିଥିଲି ମୁଁ ଆଉଟ୍ ଅଫ୍ ସାଇଟ୍ ମୁଁ ଆନେକ୍ସ ପେଜ୍ 28 ରେ ମୁଁ ସେଟା ସବୁ ସାର୍ଟିଫିକେଟ୍ ଦେଇନି ଫର୍ ମାଇ ବୋନାଫାଇଡ୍ ମିଷ୍ଟେକ୍ ମୁଁ ଯୋଉ ରିଡ୍ କରିଥିଲି ଦିଟା କରିଥିଲି page due to oversight of the draft page 28 and WPC 941.
Just a minute. The submission was made by Mr. Padhi on the other day. That petitioner earlier approved this so and so, which was disposed of on so and so. The very same prayer which is made in this writ petition was also made in this so and so. In the counter affidavit also, it has been highlighted by the opposite party in paragraph 17 that previously the petitioner sought for similar relief which was dismissed by this court on so and so, and the petitioner has not mentioned anywhere in the writ petition about the filing of so and so earlier before this court, and therefore the records of be placed. We find so and so the matter out of this so and so. Okay. It is also important, even though the petitioner has filed the rejoinder affidavit to the counter affidavit, but the argument taken by the relative has not disputed. So, what do you say?
My bona fide mistake, page 28 रे 22/5/19 के मुझे read करथिली 9413/19. Since the petition is going to be retired on 30/6/19, this court hopes and trusts that
once you similar prayer has been made in another writ petition.
No, but similar, not similar prayer. A read that छोड़ा, ये जो page 28 रे, मुझे certificate मुझे भी देई, because of oversight of the draft man. मुझे ये पे IF file करछि for amendment of the cause title with the certificate. मुझे annexer करछि page 28.
Have you filed the prayer made in the those two writ petition and the order passed in those two writ petition?
Yes, my lord. Page 28, one writ petition order, page 28.
28 could
page 28. A present reader, my lord.
Present reader. It is the withdraw खाली. We want that prayer portion.
My lord. ଏଥିରେ ଚାହିଁଥିଲି ଯେ tribunal by the
we do not know. We want to see the writ petition because once you made the same prayer,
no same prayer.
How can we know unless you seek take the liberty to file the another writ petition? If you have not done and the petition has been withdrawn, so we cannot entertain another writ petition at your instance.
At that time,
the same prayer. So to know that what was your prayer in the aforesaid two writ petition,
yes, my lord.
File the writ petition.
What was your grievance? You want regularization. What do you want?
Yes, my lord.
Regularization.
No, my regularization.
What you want?
Yes, madam. My specific prayer. The tribunal allowed my original application, directing the state railway board to give me promotion.
Then okay, it's promotion issue. And in the other proceedings also you have challenged the same promotion.
No, not challenged.
Just see 28. Just see 28. 28 is also the same thing.
28. Tribunal
28 order just see come to 28.
Since
the petitioner is going to retire on certain charges, this court hopes and trusts the authority shall comply with the order passed by the tribunal before his supervision. That means promotion should be given before supervision.
Say order tribunal judgment thila.
Same proceeding. Twist the prayer little bit here and there and keep on.
This time if we find after you file the writ petition copy, if we find that the same prayer will impose heavy cost.
Not same prayer.
Lord will see that
sure,
issue is same, but prayer little bit twisted here and there.
Let
us file.
So this is an application for amendment. It appears that in the petitioner earlier approached this court on perusal of the interim application. It appears that the petitioner earlier approached this court twice in connection with his service, that is WPC number 33098 of 2023, which was disposed of on 18/10/2023, as well as WPC number 9413/19
code election
আমি সেটা আনেক্সার করেছি পেজ অর্ডারটা
Para 2.
পেজ 28 অর্ডারটা অর্ডারটা আনেক্স
এই অ্যাপ্লিকেশনে কোড লিখছেন
আপ্লিকেশন টোটাল কিছু লেখি নাই এই ইন্ট্রিম আপ্লিকেশন লেখা নাই
ইন্টারভিউ লিখেছি তো
কোড লিখছেন another petition, that is WPC number 9413 of 2019. Let the Land and Council for the petitioner file the writ petition, the copies of the writ petitions, aforesaid the copies of the aforesaid two writ petitions, along with the order passed in WPC number 33098 of 2023. Order dated 18/10/2023, passed in WPC number 33098 of 2023. কেবে দেওয়া রাখিব আপন
মানে নেক্সট উইক আসু সব ଅଛି ମୋ ପାଖରେ
put of this matter on
এইଥିରେ ମୁଁ ଟ୍ରାଇବୁନାଲ ଯାଇଛି ଟ୍ରାଇବୁନାଲ ପିଟିସନ ଟ୍ରାଇଲ ପଳେଇ ଆସିଥିଲି
all right
ପ୍ଲେ ଦେଇକି ଆପଣର ଗୋଟେ ଗ୍ରିଭେନ୍ସ ପ୍ରମୋସନ
2025
ଆଜ୍ଞା ହଁ ପ୍ରମୋସନ ମୁଁ ରିଟାୟାର୍ଡ କରି
you file many petition twisting the prayer this way that way
नो माय लॉर्ड सी
okay it's all right you get it
next
Item 17.
अप्रूवल देला ପରେ ହିଁ
item 17
prayer is very simple
item 17
Item 17, we seek a small 1 week time. In the meantime, we will pick a dead chart and
I have objection against the order of law and tribunal. I am not getting my pensionary benefit because of this litigation, madam. Law and tribunal only remanded the matter back to the authority to conclude the proceeding.
You may keep it to next Monday also. No?
And
as prayed for by the Land Council for the Mr. Pari, Land Deputy Solicitor General, is this matter on 13th of August 2025. Yes. Mr. Sapun Kumar Ojha, Land Council for the opposite party is present. Yes. Next.
Item 18.
My lord, in this case, my lord, that the petitioner retired. Meantime, my lord, that the
Item 18 we will ready with the counter. We will file within 10 days. Mane within week. Let's me after 10 days.
telling suffering from my lord, the last applicant, my lord, so directed that counter of the file.
We are ready. We can file today also. It is complete.
Copy
Yes, we will serve the copy. Let's me keep it after 10 days.
next week.
You are making that if the counter file today and the copy is not served today to the Land Council for the petitioner, then if you file it on Monday, some cost you are also to give it. You say that it
give
is-
some cost to
give
the
some
bar.
Cost to the bar. You are the central government and give some cost.
And today we will serve the copy. Today we will serve the copy. Today we will file the copy.
For the
Mr. Kavala Panda will do it.
general submit that the counter is ready and it will be filed today, serving copy on the Land Council for the petitioner. Put of this matter in the week commencing from 18th of August 2025. You want 18th or more time because you may have to file that rejoinder application.
Even if my lord, next week, my lord,
ଆପଣ କଣ ଲେଖିଥିବେ ଆମେ ଜାଣିନୁ କାଉଣ୍ଟର ଆଫିଡେଭିଟ ରେ ଯଦି ରିଜଏଣ୍ଡର ଫାଇଲ କରିବେ ଫାଇଲ କରିଦିଅନ୍ତୁ in the mean
suffering from
okay rejoinder if any after 1 week
rejoinder
yes,
rejoinder if any
file in the
1 week
meantime.
my that
25th ତାହେଲେ ରଖୁଛୁ ଆପଣଙ୍କୁ
my lord,
25th 8 2025 ତାପରେ ଲେଖିଦିଅନ୍ତୁ ରିଜଏଣ୍ଡର if any is filed in the meantime. Yes. Serving copy on the Land Council for the Union of India.
Item 19.
Please, your lordship. Mr. Subhankar Rao is on his lips. My lord, kindly.
Passover. Okay.
Item 20.
This is a matter of a Kendriya Vidyalaya KV Sangathan that switching over from CPF to GPF.
Who is appearing for?
I am appearing for the one. OP1 and I am appearing for the OP1 and 2 for Kendriya Vidyalaya.
What is the prayer here?
My prayer that to quash the tribunal order, while the tribunal has heard 5-6 matters together from CPF to GPF, and dismiss the original application by stating
Which,
you have
which is
opted
your original application? OA number is
231.
231.
31 of 2023.
23.
That order is in which page?
That is in page 66.
50?
66, my lord.
66.
In this way, the applicant joined as librarian.
No, এটা তো লেখা আছে 231 of 2021.
231, 2021.
ଆଉ ଏପଟେ କଣ ଲେଖା ହେଇଛି annexure 3 ରେ order 231 of 23 ଲେଖା ହେଇଛି.
That is the common order and the leading case. The 214 by 2021, there are 5 cases. And common judgment passed disposing 5 way on that day before the tribunal 5 cases.
But this case
and the leading case is the
31.
Sandhyarani Patel 214 by. And 31, this present petition case reflect in 36 as she has.
Para 66.
After discussing that case and that. Because all are cyclostyle case and identical.
So the number is 231 of 23, right?
This is
21, my lord.
21.
You come to your prayer, madam.
23 कर दीजिए आप.
ସେଇଥିପାଇଁ କହୁଛି ତ ଆପଣ.
Sorry.
Prayer 23 कर दीजिए.
That order is 2012. Way number.
Page
ওই নাম্বারটা ভুল লেখা সেইଥିପାଇଁ ମୁଁ କହୁଛି. ଆମେ ସେଠି ଦେଖିଲୁ ଯେ ଯୋଉଟା
year also.
My mistake.
Year number as well like year also.
हाँ.
ତାହେଲେ
टिकट चेंज कर.
no you ওই number भी भूल.
No, number question ही भूले जाए
Just file that interim application, correct it so.
My lord.
And you also has to file away copy. As you also always directing to file the
copy of
original
OA.
application.
File the my lord counter.
Not file the original application as my lord always directing to the.
You have filed the counter affidavit.
Counter affidavit I have
And
filed.
resender also you have filed. Only
I have also attached all, but he has to file away original.
all right,
Technical thing I will follow.
No, it's all right. The learning counsel for the petitioner, Ms. Mahapatra submits that inadvertently in the prayer portion, the year of the OA has been wrongly reflected to be 2023 instead of 2021. Na?
My lord.
21.
First page of.
And it's also first page.
हाँ, एक देखो तो ना OA पूरा guys 214 of course.
That's leading case.
And
पूरा टका रखो.
in the
This is the leading case. My one.
But you have to clarify.
Yes, that's right.
Clarify.
So I
and
will in the prayer.
କାହିଁ ସେଗୁଡା 214 କଣ ପାଇଁ ଲେଖିଲେ ଆପଣ ତ
214 and batch ଥିଲା ନା ସେ batch ରେ
and batch ରେ ଆପଣ ନମ୍ବର ଦବା କଥା
ଆପଣ ଟା ଦେଖିବେ ନା
ଆପଣ ତ 214 ର ଅର୍ଡର ଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁନାହାନ୍ତି ନା ଆପଣ ଚ୍ୟାଲେଞ୍ଜ ହଁ ତମେ ଲେଖିବା ତ ସେଠି and in also in the cost title and she intends to file an interim application for correcting the same କେବେ ଫାଇଲ କରିବେ अच्छा put up this matter in the week commencing from 18th of August 2025 with the interim application if any filed by the learned counsel for the petitioner who shall also file the copy of the original application. Yes.
Let copy maybe sir.
Who copy?
We will file.
देबे file करना थी परंतु. Yes, next.
Item 21.
Please my lord. Yes, please my lord.
Item 21, your lordship. Last occasion, order dated 4th July 2025. Lords
We
directed.
took time to file the counter. We have reduced the counter by Monday.
The Mr. Pari.
Last multiple occasions, this submission is being made. The
We have
first order
taken
was
time. We ready also. We will reduce the counter by Monday. We will file it.
Not to argue any matter.
No, my lord. This is a deficiency of rule 50 of the CCS rules, which is we already got. We will file by Monday. Monday or Tuesday we will file it. That's why keep it to.
बाहर दे प्रत्येक मैटर रे आपण दीटा रो अधिक नेला माने कॉस्ट डिपॉजिट करियो एडवोकेट सोल्फियर कोन लखन the
सरकार बाद तो ऑफिसर आस करना दे
Mr. Padi and Deputy Solicitor General submits that the counter is ready and it will be filed Sunday, serving copy on the land council for the petitioner. Put up this matter in the After going through the counter affidavit, if you intend to file any rejoinder also file, we are fixing it on 25th. Right, so that put up this matter on 25/8/2025 after receiving the counter affidavit, if any. If the petitioner intends to file the rejoinder affidavit, same shall be filed in the meantime. Judgment
Item 22.
I'm for the opposite, but I. 33. In actual board, item 33 is OSFC matter. That OSFC Caesar matter. Item 33.
23.
Yes, 33.
33.
So the buyer is appearing today, probably. He's filing wakalat number. We are looking at it come on 18th. 19th.
Who is appearing for whom?
20th. 20th.
Yeah, let's just also serving copies of the contract, copies of the contract.
Auction purchase. Auction purchase.
Auction purchase.
Auction.
Buyer is appearing. Item 20th.
Yes, sir. This is for respondent number 5.
Yes, 5.
Yes.
Completed.
And it is copy has been served on.
Yes, sir. Yes.
The learning council for the respondent number 5 has filed counter affidavit today in court, which is taken on record. The copy of the counter affidavit has been served on the learning council for the petitioners. So also the Mr. Das, you are for?
Corporation.
For the corporation. Kinds of matter that
33.
thank you. For the OSFC, this is taken on record on consensus of all the parties. As like Mr. Subir Palit, land senior advocate appearing for the petitioner. So also Mr. Das, senior advocate appearing for the corporation is present. On consensus of all the parties, this is of OSFC for that is opposite party number 2, 1, 2, 3 and 4. That is for the Mr. Das is appearing. Put up this matter. Kebe kohile rakhiyo apne? 20th August 2020.
Mr. Palit, if you want to file rejoinder, file it.
I'll file.
Rejoinder, if any, be filed in the meantime by the land council.
Both the senior counsel must give the briefing council's name. It has to reflect in the.
Sashan
Patel, please give
it
it
right.
Great. Great. So interim direction will continue.
Interim order
4/7/25.
4/7/2025 is extended till
Great.
next week. Yes.
Great.
Item 22.
Short.
22 you want?
Short
At-
Passover.
Passover is on.
No, whenever the
Short
message is
pass.
coming, paying for Passover.
Passover को court रे held up है तो अपन Passover केम दिया पूछ को?
और अच्छे एक नंबर को प्रोसेस 70.
Actually, problem हो तो.
Yes, ma'am. I am waiting.
Yes.
Item 23.
Please notice. Second round of written application. Auction purchaser. The petitioner is auction purchaser.
I am appearing for the grant. Mishra is pending the auction purchaser could not is handed over before him because the section 14 was not allowed. And 1(8) is section 14 has allowed. So it may allow some time to hand over the possession to the auction purchaser.
Now it's allowed.
By section that are pending,
We can dispose it of.
yes, it comes to
The
Subject to my lord's approval, can you make one submission not bothering my lords? Next, can you make a prayer subject to my lord's?
the application has been allowed. They are
No, but
making a submission. They will hand over the possession to you on Monday. And what further we will keep this matter pending. That is your
That's not the
prayer.
record.
The
deposit the requisite fees before.
all right. The writ petition has been filed by the petitioner Ullas Swine with a prayer for a direction to the bank to register the land appertaining to so and so. The land council, Mr. Mohanty, land council appearing for the bank submits that the bank filed application under section 14 of the Surface Act before the
CGM cutter.
CGM cutter.
And CGM 1(8) the order has.
And the order has been pronounced on 1/8/2025 2025, and on the basis of such order, the possession of the property is to be handed over to the petitioner on 11th.
Because we have to deposit the requisite to the commissioner of police.
ଆପଣ କହିଲେ ନା
No, we will hand over after deposit in compliance.
No, no, ସେ indefinitely କୁହନ୍ତୁ ଆପଣ give a date because you are disposing of the petition. Tell us a date.
We will deposit before.
By 14th we are telling you, giving you time.
Deposit before the bank may be ordered that so that basically of the commissioner of police will accept.
We can't write every procedure. 14 is allowed, you give the position. You tell us how much time.
What time you require?
You will do this, you will do that.
Court fee ଦେବେ ଅମକ ଦେବେ ସେଗୁଡା we are not supposed to.
3 weeks time.
Maximum 3 weeks.
3 months within the video. Commissioner will cooperate. That way.
Submit that the position will be handed over to the petitioner by 1st of September 25 positively. Accordingly, the petition is.
One thing that the commissioner will cooperate. That is, accept for the fee.
Next. Not right. Yes.
Item 24.
The opposite party. And pray for an adjournment.
Here actually there is a departure from the normal procedure. Section 14 application has been rejected. Bank has filed.
You are the auction purchaser.
I am the bank.
Bank. Your application is rejected.
This application has been rejected by the CA. But on the ground that a reconveyance deed has been executed, discharging all the mortgage property, and therefore there is no secured asset, and therefore section 14 cannot be made applicable. But interestingly, a young lady probation officer was there as the manager, branch manager. She was told by the other side, out of 15 crores, 9 crores amount was outstanding. She was told that if you release one item of property from several items of mortgage property, then I'll sell it and pay back the money. So she thought the bank will get the entire money. So she, in good faith, because there is one composite document, she executed a deed of reconveyance.
Against the final order passed under section 14.
14.
The rejecting your petition.
Writ is maintainable.
Writ is maintainable.
Therefore, when she executed the deed of conveyance, instead of giving back the other properties,
No, just because some of the decisions say that it is not maintainable. You are
no,
to the
I have got the direct decision point. Bajaj Finance case.
Just you are appearing for whom?
Opposite party number 2 to 4.
Who are you? 2 to 4 one key.
The borrower.
Who is the auction purchaser?
Mr. Mishra, who is the auction purchaser?
Have you implemented auction purchaser? Have you implemented auction purchaser?
Sir, auction purchaser.
No. He is affected. He
is the main party who is. Why have you not included as party?
Sir, auction purchaser actually, if I lose in here, auction purchaser will not get anything.
So he has a say. After all, he is the beneficiary or everything.
So
You must have deposited the amount also.
No, already sold.
I can see what
No. The rate is maintainable.
Just add that thing.
Auction purchaser. Who is auction purchaser by the way? That bank officer.
Sir, I got only 2 copies. I just read that part.
Oh, yes.
Para 28 clause 4 of that clause.
Para 20.
Para 28.
No, about the Supreme Court decision we are telling. There because there are some number of decisions, I think against 14.
No,
you are
so that is a little bit different. Anybody who is agreed by the order of the.
You are also aggrieved because your petition has been rejected.
Section 17 deals with, so the borrower is concerned. Here the credit, secured creditor. If a lordship looks at page 28, paragraph 28.
Paragraph 28.
Paragraph 28.
Clause
of the judgment.
Yes, clause which clause?
Next page, clause 4.
Next page.
The secured creditor would have the remedy of invoking writ jurisdiction under Article 226 of the Constitution.
Where are you reading?
Clause 4, my lord. There are 6 clauses in paragraph 28. That is quoted in the Supreme Court judgment.
In view of in case the district magistrate fails to pass an order
So
in
that
terms
is
of the provision,
inner phase 13.
same is not true. Yes. 226.
But the judgment that has been quoted para 33.
No, if the order is passed, it's not implemented, then 226.
No, if no order is also passed. Terms what is provided in section 14 fails to pass, or if the same is not being implemented. He has failed to pass, he has rejected it.
No. I think we let us keep this matter to next week and
The Supreme Court also has
let us say, suppose the bank has filed the petition under section 14 and it has been rejected. Question is that whether writ is maintainable or you have to go to the section 17 before the DR.
No,
that is the
limit. That is not exactly.
Which paragraph exactly you are
not clear?
Sir, 29 का ऊपर है.
29 ऊपर, yes. 4, 5, 6.
Clause 4.
Clause 4. Just read it. In case
if the district magistrate fails to pass the order in terms of what is provided in section 14, or if the same is not being implemented, the secured creditor would have the remedy.
If fails to pass. Fails to pass is something different. Fails to pass means if it is delayed.
Like they
doesn't pass the order.
They are coming now. The such petitions are also
those petitions are entertaining. Fails to pass. Your application was filed. He fails to pass the order. He doesn't dispose it up. Then it is. Or otherwise, if it is order is passed, if it is not implemented, in that case also 14 lakhs. But today your case is it is rejected.
Rejected. That is the difference.
That's the distinction.
Please satisfy us on next week.
I think.
Please file the
decision. But we can see section 17.
No, we want decision. We know that what is section 17. Just
the thin distinction.
Because
fail to pass means every day we are passing the order.
This
14 is filed, not disposed of. We are saying 60 days we have to dispose.
This petition has been filed by the Union of India.
That's simply adjourning.
Union Bank of India.
SEC phase 1 also.
In any case, you have to
challenging the
next week you will fix it.
Challenging the order dated 24/12/2024 passed by the Learned Chief Judicial Magistrate Panjam Berhampur in Miss Case number 259 of 2024. That is under Annexure 1.
Yes, Annexure 1.
Annexure 1. In dismissing the miscellaneous case, stop. When we pose a question to the land counsel for the petitioner as to whether writ petition against the impugned order is maintainable before this court, land counsel files a division bench decision of this court in the case of Bajaj Finance Limited versus Ali Agency and others, reported in AR 2022, Orissa 68, wherein in paragraph number 28 bracket Roman 4, it has been held as follows. We are of the view that the nature of the order passed in this in the impugned order does not come within the two categories of cases which has been mentioned in the aforesaid paragraph. Hello? The Land Council for the petitioner further placed reliance in the case of Harshad Govardhan Sondagar versus International Assets Reconstruction Company Limited and others, reported in 2014 6 Supreme Court cases, page 1. Which paragraph?
29.
Wherein in paragraph number 29, it has been held as follows. Quote. The Land Council for the opposite party number 2 to 4, 6 for an adjournment, put up this matter on 13th
Auction purchase to made
on 13th
meantime,
of August 2025.
I'll take steps in the
Mr. Mishra, Land Senior Advocate, submits that steps shall be taken in the meantime to impede the auction purchaser as one of the opposite parties. On the next date, the parties shall address about the maintainability of this writ petition.
as well as the merits.
As well as the merits.
No, suppose you implead it, next time again we have to issue notice to the auction purchase. Meanwhile, take out notice.
If he appears
You bring,
third party,
maybe you are bank
they
officer.
must be voting the fence.
Maybe you are bank officer, bring him.
Okay.
And I would like to make a request now.
Yeah.
The 34 item was mentioned.
34, we have just disposed of the given time limit to that. That was his prayer.
That was his prayer, but I had appeared. But I just wanted to bring your one notice. There are two decisions on the subject.
No, we have not stated anything.
Right.
He stated that because of the voluminous file, please give us some time to. We said that you have to do it expeditiously because of the provision stipulates the time. We have not expressed any opinion.
So that
We have-
also Supreme Court has clarified. It is directed, not mandatory.
No.
Therefore, we have said that.
We have not.
Dispute on disposal.
We have not.
Or I just want your worship should take note that the objections filed or applications filed by the opposite party, because the Supreme Court says it has to be considered.
We have not stated anything whether considered
No, that has
considered.
your
We have just stated that it is to be
My submission is
expeditious.
E by 3 and F by 3.
You have moved many application 711.
that has to be considered because the law says that.
And we are not saying anything.
We are not saying that it will not be considered. We say that whatever you do it expeditiously. Only one line we have stated.
Hearing the parties.
Obviously, that is the.
No, it should be hearing the parties.
Okay.
Both the parties should be heard.
Okay, that we let know.
अच्छा इधर खाली ये जो application नहीं किया
After hearing the party.
after hearing
Please, after hearing the party.
item number 34 हाँ yes
As expeditiously as possible.
सेटा लिखा है ये
That we have.
Yes. I just wanted that should be taken.
and Mr. SP senior advocate Mr. Gopondu Das for the opposite parties really
He has come.
Mr. हाँ से खाली कहउछंती से सबु रहिबो खाली हियरिंग दी पार्टीज खाली 8 टा करियो
ଆଉ ଯୋଉ ସେ ତାଙ୍କର ହିୟରିଂ ପାର୍ଟ ସରି ଯାଇଛି ଆମ ବ୍ୟାଙ୍କ ପାଇଁ ଅଛି
Whatever.
ଆଜ୍ଞା ସେଇଥିରେ ଲିଙ୍ଗରିଂ ହଉଛି ଆଜି କି 2 ମାସ ଉପରେ ସେଇଥିପାଇଁ ଆପଣ ଅର୍ଡର 7 ରୁଲ 11 ର କୋଡି ସ୍କୋପ ନାହିଁ ଆଜ୍ଞା ସେଠି
we are not entering into that as expeditiously
First of all,
same order
no I have not mentioned in absence I have told
All I did,
that my senior is appearing in this case.
because of the formal nature of
Right.
case.
Yes, ma'am.
All right. Next yes Hasina.
On the basis of the reasoning mentioned in the preceding paragraph, the writ is declined.
I agree.
Item 25.
What the opposite party? Which was the petitioner?
For the opposite.
Which was the petitioner there? Mr. Pramod Kumar Rao. Yeah,
26.
25. What is the matter?
Matters it is concerning order passed by the learned ombudsman. And there are several writ petitions filed before this applicant writ petition. And those are already dismissed. And some cases was disposed of with a direction to the opposite party to verify and correct it. But thereafter, he approached the
जो display board mentioned item 25 chances. Let us wait or we can adjourn it because your friend is not there. Yeah. When counsel for the opposite party is present, non-appeals for the petitioner. This matter in the week commencing. Any interim order has been taken? No. This matter in the week commencing from 25/8/2025.
Item 26.
May I please, Your Lordships? My Lord, kindly see order dated 19/3/2025. This is a case of transfer, my Lord, to a post where there is no post available for me, my Lord, to be accommodated. 19/3/2025. Your Lordships, paraphrase, my Lord, what will this?
We have given time to opposite. Now they have filed the counter affidavit.
I have also filed rejoinder.
Also filed the rejoinder. So pleadings are complete. Yes, sir.
I have received the rejoinder.
Okay.
So, my Lord, I have highlighted that it's a punitive transfer. I have given the sufficient documentary evidence to prove that. And Your Lordships indicated it will be disposed of at the stage of admission. And
it's all right.
Since your last occasion, director, why don't you join and come back? Well, I have joined there and waiting for disposal of this case.
Which order you are, by the way, challenging? Order 11.
Yes, sir.
So all the decisions which are against you have been quoted by the learning tribunal. Those are all the Honorable Supreme Court's decision that in transfer matters, what should be the...
You are imputing malafide against whom?
Well, against the person who has passed that order. I have said,
Who has passed the order? Who has passed the order?
that is, my Lord, that order was passed by. That is, my Lord, Annexure 7. That was passed by regional director in charge.
But in paragraph 14, it is mentioned that though the appellant alleged malafide, but not produced any document
Well,
that the transfer is actuated with malafide exercise of power.
I had applied at that point of time also. I had applied for RTA application. That was
No. The first principle is once you plead malafide against anyone, you have to implead him as a party. This is the law. How have you not impleaded him in pleading malafide?
My Lord, I have made my
regional director against whom you are pleading malafide.
I have made him
not even impleaded him in the original application.
that authority as opposite party.
Malafide ground goes.
My Lord,
what else remains?
My Lord, I have impleaded that party who has passed that order.
No. Against whom you are pleading malafide, you have to implead. That's the law.
Of principle of natural justice, Mr. Tripathi, behind back you say malafide, he has done it, but will not give, the court will not give any opportunity, and some adverse order will be passed against him. So that is the reason why it is consistently stated, as my esteemed brother has pointed out, that if you allege malafide, then you have to implead him party.
Since, my Lord, I have made him as opposite party number 3, not in person. Your Lordship, permit me, I will make him a person.
But in the original petition, you have not done it. You can't implead him here.
Well, since that order has been challenged, and this Honorable Court had the occasion to deal with that, and specifically, my Lord, no post to be transferred. That's why I specifically asked them to take instruction whether there was any post.
If your challenge is only on the basis of malafide, then against whom you are impleading malafide, you have to plead malafide. You have to implead him.
My lord, your lordship is absolutely correct. Even if my lord malafide ground is not there, no, is gone, my lord.
Then what
Document is not there. Malafide ground.
Document nahi.
Malafide.
Document yaku taku add karnahanti, and so how it will be you are justified in view of the limited scope in interference of the transfer matter, as number of decisions in that respect has been relied upon.
My lord, and all those decisions, my lord, say one thing, that you have to approach the authority. Here, my lord, I have approached the authority. Thereafter, I approach the tribunal.
Know the scope of interference in the transfer matter. So that's the condition of service. So you have to go from one place to another unless there is something
violation guideline,
and it is made in administrative ground, and unless the strong and pressing grounds are there, what is the question of declaring such a transfer order as illegal?
My lord, if your lordship can see the rejoinder affidavit,
Any kind of, you are not even alleging that any kind of statutory rules have been flouted, but you are saying that it is a question of malafide.
I have said violation of the guideline, transfer guideline. That was my specific case, apart from malafide, my lord.
No, but the learning tribunal has held that only on the ground of malafide you challenge it, but did not produce any document. And in addition to that, you admit yourself that you have not added that man as a party.
No, I cannot dispute that, man. I cannot dispute because I have not made party for the time.
And that goes, your entire thing goes.
My lord, if your lordship kindly see, even if your lordship kindly see that rejoinder affidavit, I have said I have obtained instructions from the RTA. The officer, my lord, Jakepur officer says there is no post. When he was called upon to indicate whether there is a post or not, he himself indicated that there is no post. Still then, my lord, he has transferred me.
No, you have already joined. What is the question of not whether there is any post? You yourself said that you have already gone and joined there.
No, because your lordship indicated at the time of admission.
So you joined there. Vacuum to no nothing na. But a post upon join kartive, charge nahi thibe, sign kartive. So that post is existent. Why do you say that there is no such post?
My lord, let them indicate, my lord, there is a post available. That's why, my lord, your lordship directed them to take it. On that is
paragraph 57 इसके अनुसार judgment in that judgment I appeared in that matter.
Yes, sir. In that case, your lordship.
I know this is really nothing. So they formulated the entire transfer. This very categorical says that it is a incident of service. You can't.
I don't dispute that, my lord.
It's not open to judicial review at all, except on the ground of malafide. And unfortunately, you don't have the ground of malafide. You can't substantiate that. You have no document. You have not impleaded the person against whom you impute malafide.
Well, 93 Supreme Court says even the violation of malafide as well as violation of the regulation or the guideline.
All right, hard the learning Mr. Tripathi, learned senior advocate for the petitioner, and you are appearing for whom?
Nihal Rath, madam, on behalf of
Mr. Nihal Rath, learned counsel appearing for the opposite party number
2 to 4.
2 to 4, and Mr. Learned counsel appearing for central government for opposite party number 1. The petitioner Prashant Kumar Sahoo has filed this writ petition challenging the order dated 4/3/2025 of the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/00678 of 2024, in dismissing the original application. Stop. It appears that the petitioner filed such a original application to quash the order dated 14/11/2024, wherein while working as head clerk oblique assistant in ESI Corporation, Odisha region, he has been transferred and posted to branch office, JK Pur, Rayagada on administrative exigencies. With a further prayer that is entitled to TA/DA and joining time as per rules. And he stood relieved from the posting as head clerk so and so with effect from 14/11/2025. After issuance of the notice, the opposite parties entered appearance and filed their counter affidavit, wherein it is stated as follows, quoted paragraph 3, the case short properly. The London Tribunal, after considering the ratio let down in the case of Yodaka decision site for so came to hold that the appellant has alleged malafide against his transfer, but did not produce any document in that respect that the transfer is actuated with malafide exercise of power. It was further held that when the competent authority transferred the petitioner to branch office JK Food, it is up to the authority concerned to allow him to continue to his transferred post after he reports to duty. In the meantime, according to Mr. Tripathi and senior advocate, the petitioner has joined the place of posting. Admittedly, not only no document with respect to the malafide has been produced before the London Tribunal, but also the person against whom the malafide has been alleged has not been arraigned as a party.
Regional director.
That is the regional director has not been arraigned as a party in the original application. It is something after hearing the Land Council for the parties and in view of the ratio let down by the Honorable Supreme Court, we do not find that there is any kind of malafideness on the part of the authorities in issuing the transfer order, or that such transfer order is in violation of any statutory rules. Stop. There is no illegality in the impugned order. Therefore, we are not inclined to give the relief as sought for. Accordingly, the writ petition being devoid of merit stands dismissed.
Only one prayer, my lord, with the lordship's leave, my lord. Lordship may indicate I have filed a regional affidavit indicating that
in this writ petition, counter affidavit filed, and the regional has also been filed by this one. So, yes, next.
Item 27.
Pardon, Your Lordship, in item 27, Lordship,
senior has to join from basic. Due to some technical issues, he has given me instruction that till now counter has not been filed from Union of India, Lordship.
Mr. Pari. Who is appearing for Union of India? Mr. Pari, here also you took time earlier for filing the counter affidavit, and the last time you took it on 11/7/25. So what is the position now?
So we sought for instruction, but we not receive as yet, man. Another more time may be given.
That is 11/7/2025. You sought for 2 weeks time, and 2 weeks have already passed.
Committee, let's me issue notice. I'll take instruction.
That's the last chance maybe given. So 2 options are available with us now, that to impose the cost or to ignore the counter affidavit. Even if you filed, we will ignore it, because you are taking time. Today this is.
Well, I am applies for them. I am issuing a circular to the department. Let's give me 15 days time. Thereafter, let's partners. I am issuing a circular to all the departments if they are.
Because this.
Yes, I am understanding the law.
The first order was important time is in March 25, and we are in the month of August. So since that day you are telling that you will file the counter affidavit. So 5 months have passed. All right, the Deputy Solicitor General submits that though instruction has been sought for to prepare and file the counter affidavit, but the same has not yet been received, and for the 2 weeks time be granted to file the counter affidavit, put up this matter, and they will commencing from 1st September 2025. Yes.
Item 28.
Your Lordships, in item 28, my senior is on legs. Pray for a short passover, my Lordships.
28, you are appealing for whom, madam?
Petitioner, my lords, on behalf of Mr. Siddhant Dwivedi.
You want Passover or adjournment?
Just a passover, my lordship.
I am for the borrower, my lord. I am filing my counter affidavit.
Okay. Have you served the copy?
Yes. Since long I have served, because if not reached, I have not filed.
Filing the counter then. It will be scanned, na?
It is in list since long, for that reason I have kept it with me.
No, it's filed so that the scanning.
It is scanning heap everyone.
Again.
The learning counsel for the opposite party number 3, Mr. Biswal, submits that the counter affidavit copy has already been served on the learning counsel for the petitioner. So also the learning counsel for the opposite party number, and he will file the counter affidavit for the court in course of the day. Matter will be placed on 18th of August 2025. The learning counsel for the petitioner is present through virtual mode program. Yes, next.
Obliged.
I may be pardoned, Your Lordship. Item 27, Your Lordship.
27, it is posted to 1925 because the counter affidavit has not yet been filed, and Mr. Pari took time to prepare and file the counter affidavit, right?
Obliged, Your Lordship.
Yes.
Item 29.
Your Lordship, on behalf of Arun Panda, Your Lordship, kindly 2 weeks more time to review for final hearing. Already we have filed the rejoinder on 4/8/2025.
Yeah, I got the opposite party. The petitioner here challenged the option notice.
What is your name, ma'am?
J.R. Patnaik, Jinu Rani Patnaik.
Like you are mentioning on behalf of Mr. Niranjan Panda. Is Mr. So appearing for Mr. Niranjan Panda submits that the pleadings are complete and the matter be taken off after 1 week for final disposal. List this matter in the commencing from 18th of August 2025. Yes. Okay. The Land and Council for the You are appearing for ICICI Bank.
Opposite party number 1 to 3,
Opposite
ICICI Bank.
party number 1 to 3 is present, no? Yes.
Very sorry.
Item 30.
Item number 28, Vinod, I'm very sorry.
Item number
28. My learned senior request, my learned senior is here. I've made an application for amendment. That may be allowed, Vinod. That's the only place.
28 who?
Copy of the
28.
amendment petition.
The counter
On the
will be
last
filed.
data is submitted.
We asked him to file the counter affidavit in the counter so that it can be scanned and
What
it-
they know to pay
one amendment application has been filed.
Yes.
Have you received the copy?
No, my lord, copy is not.
Give a copy. Radhe lekhi deva add kar diyantu. IN number 1 so this is an application for amendment. Mr. Biswal and counsel appearing for the
Option number 3.
opposite party number 3 submits that he has not received the copy of the interim application. Have you got stop? The land counsel for the petitioner served the copy of the interim application on the land counsel for the opposite party number 3 in court today. Court of this matter already he is now also for consideration of the interim application for amendment. All it's on that day it will be considered.
Item 30.
I think 30 on behalf of Mr. Bose, my lord. They will file in one IA. They file one IA with 1 month time to objection.
IA for?
IA, they file IA for stay, vacation of stay. We need 1 week time to file objection.
But in the meantime, so far as licensee is concerned, the counter affidavit I was required to file, it is there. Malab, I'll file it on Monday because the officer was on leave. I'll file it on Monday. The vacation has been filed by the private opposite party.
You will simply adjourn it.
Right.
There is an entry.
We will not.
Put of this matter as prayed for listening. List this matter in the 18th August 2025. Yes.
My lord, there is an entry.
Do in the meantime whatever you want to do. If you want to file the count objection to the IA, you file it. Is there an interim order?
Yes, that is what it is.
Interim order dated kebe?
That's 2nd May.
2nd May 2025 is extended till next date. Yes.
Oh, bless you.
Item 31.
May I please, Your Lordship? On behalf of SK Tripathi, for 2 weeks time. 2 weeks time.
What do you want?
On behalf of SK Tripathi, pray for 2 weeks time.
Who is appearing for the other side? He appeared Kuchandi? No. None appears for the opposite party. Mention is made on behalf of Mr. H.K. Tripathi for adjournment. 2 weeks for adjournment. 1st September 2025.
Item 32.
Item 32, Mr. Samit Kumar, Mr. Senior Advocate, will ask you some difficulty to that next week.
Who is to argue on whose behalf?
Behalf of the petitioner.
You are appearing
I am for the opposite party number 2 and 3 bank.
2 and 3. The learned counsel for the opposite party number 2 and 3 bank is present. Stop. It is stated at the bar that Mr. Samir Mishra, land senior advocate, is to address the court on behalf of the petitioners. And today he has some personal difficulty and the matter may be taken up in some other day. List this matter 18th August 2025. Yes.
Interim order.
Interim order is there. Kebe.
16/5/2025.
16/5/2025 interim order shall continue till next day. Yes.
8 September.
18/8/2025 रे सोमवार को रहेगा. कितना?
Pass over item number 19.
Authority not level. Acha, non appears on repeated call. Arjun Purjan. Any other one?
Item 22.
22.
That's from the petitioner.
You are for the petitioner.
License.
Who is for the?
That's, I think, my learned senior Mr. S.C. Das was here when the matter was called. Now,
You sort of
yes, I sort of also. I think he has been held up in.
So let us take it on some other day.
Yes,
on the prayer of the land council for the petition matter is adjourned to Author for them. Author 2025. Yes. 35 on the.
Item 35.
The one present adjourned.